Jason Derulo playing for you on The Morning Fix. Jason Derulo is no longer a singer. He's a TikToker.
Yeah.
He is
Agreed,
literally a
100%.
TikToker.
Yeah, that's what I think. He makes more money there.
On TikTok than in music. Well, considering he's not come out with anything in a while, the last song was a TikTok song, so that doesn't count. Surely that doesn't count, but you are joining us on The Morning Fix. Today is Trial Tuesdays, one of my favorite features. We're in partnership with CMS Daly Inamdar to bring you all the legal knowledge you ought to know about. We're joined virtually by Colette Akwana and George Mushiri from CMS Daly Inamdar, and we have loads more employment law questions for them.
Yes, that's right. I spoke about domestic workers. However, I've got another person asking us to question them. Basically, he's specialized in a field, and then he says, there's a non-compete clause given to me by the company, and it's like moving to another competing firm is the only way to advance in life.
Yep.
Right? Because it's a specialized field. So can my employer really say I am not allowed to work at a competing firm, is what this anonymous person is asking. George, maybe you can take this one.
Broadly, these particular clauses are usually, you might find them in quite a number of contracts of employment. In themselves, those particular clauses are not illegal. But they can be determined to be illegal when, upon assessment, they prove to be unreasonable to the employee, because each and every employee has a right to earn a living according to the Constitution, and so on and so forth. So the basic determination as to whether it's fair or not will depend on various factors. Some of these factors being how long have you been prohibited from going to another employer, or from seeking an alternative employment, and also if that particular restraint is too wide. Perhaps you're told you cannot work in Nairobi, or you cannot take up alternate employment in Nairobi, Kiambu, Nakuru, and Mombasa. So those are the considerations, some of the considerations that are taken in consideration when determining whether that particular clause is fair to the employee. It shouldn't be too wide. The duration also shouldn't be too long. But also that depends also on the sort of profession that particular employee is engaged in. Because if it's a very specialized area, then some of these restrictions might be considered by a court of law to be reasonable.
There you go. Non-compete clauses can be legal, but they shouldn't be too harsh.
Exactly.
I think that's what I always think about the law. It's all about fairness. So something might be allowed, but if you think it's gone too far, you might actually have a claim there. So thank you so much for answering that for us, George. If you have some more questions, 0758 123 444. This is Trial Tuesdays on Radio 44.